Any mention?
I beg to mention item number 6, Lordship.
Yes.
I'm praying for 2 weeks' time, Lordship.
Which the other side?
No objection, Your Lordship.
You are there for the statement.
NG shall last there, Your Lordship.
There is no objection.
No, Your Lordship.
6 after 2 weeks.
Yes, Lordship.
And the request made on behalf of the petitioner. Yes.
Oblige, Lordship.
My lord, I beg to mention item number 2, my lord. I'm praying for 2 days' time to prepare the matter, my lord. Mr. Paul is not here, my lord, so I have an instruction
You are good, man.
My lord,
This court
tomorrow,
has
my lord.
given
Tomorrow. My lord, can I fix it
enough
tomorrow?
indication on the last occasion also. It's a 2014 matter.
My lord.
It's too much.
So I'm praying 1 day time, my lord, to prepare the matter, my lord.
Take it up.
Tomorrow, my lord.
Last time this matter was heard.
Which one?
Oh, sorry.
Item number 2, sir.
See, madam, this court would definitely like to accommodate lawyers. But then, you see, it should not go to the way you are asking time in these matters. You see,
My lord, I
repeatedly.
understand, my lord. That's so, my lord. I'm praying for 1 day time to prepare it, my lord. I'll start it, my lord, tomorrow.
No objection, Your Lordship.
We will give you one week, but then remember it will go as a last choice.
My lord. Yes.
Just say the request of the petitioner, this matter after 1 week. Item 2.
Highly obliged.
Oblige, Your Lordship.
There will be no more accommodation. No?
My lord.
Your Lordship, I beg to mention item number 5.
Yes.
Your Lordship, I pray for 2 weeks' time, Your Lordship.
You are making a mention on behalf of the petitioner.
Yes, Your Lordship. And for the petitioner.
Speak a bit loudly. This court cannot hear you. Yes, when do you want it? Why you are making a mention? Why do you want adjournment?
We are not ready, Your Lordship.
When do you want it?
I pray for 2 weeks' time, Your Lordship.
We have no objection.
2 weeks on the request made on the petition. Okay.
I'm right.
Yes.
Supplementary cause list, item number 1.
Lordship.
Yes.
Lordship, this is a 482 application. Certain peculiar circumstances where my lord, FIR was lodged against this particular petitioner. The allegation was that the girl is a minor. Now the prosecution story is that her date of birth is 2005, whereas there are as many as 4 documents: the Aadhaar card, PAN card, voter ID card, and the school certificate. Everybody says, or every document basically
This is what
says that
this is a POXO matter.
Yes, Your
POXO
Lordship.
matter, my lord.
Lordship,
They are seeking quashing of the.
entire
This
process.
matter has been charge sheeted.
FIR
Yes, Your Lordship.
Yes.
My lord, before I proceed with the case, my lord, I have to pass through one hurdle, my lord. That is, my lord, I had filed a GMA application before the court below, my lord. But apparently, on the face of the record, my lord, that it was withdrawn. Withdrawn, my lord.
Jimma of what?
GMA of a vehicle, my lord, offending vehicle.
You are the registered owner.
Registered in the sense, my lord, I have got a salary in my favor, and all.
You are not a registered owner. Your name has not been entered.
We have not transferred that. But my lord, now my lord, we filed one GMA application before the trial court below, my lord. IO was called, and IO was against the releasing of the vehicle.
That is common.
No, my lord,
procedure.
sensing the, my lord, understanding the mind of the court, my lord, it was withdrawn, my lord. Now having, without filing a second petition there, my lord, I am before your lordship.
How can it be?
My lord, that is what, my lord.
You cannot.
If I am allowed to, but this is a very feeble attempt, my
Where is
lord,
the
I know
order?
that.
What is the order of the court?
My lord, it is at,
It is at page 21, Your Lordship, annexure 5. They had withdrawn the Juma application
page
on
21, my
grounds
lord.
of error, not because that the IO was.
I have
resisting.
submitted, I have frankly submitted that, my lord.
We will not take into consideration anything which is not supported by record.
My lord, yes.
So definitely your statement will not override this order.
My lord,
There
yes.
is no question.
My lord, yes.
Mr. Gurung, you will not have any of these things, any relief from here.
My lord,
It's up to you.
is there any, my lord,
You cannot just say that just because the court below will reject it, you withdraw that petition and you
you
are
file
invoking 482.
My
This
lord.
is not law.
And Your Lordship, when there is a specific provision, statutory provision in the code,
definitely.
then why would they invoke inherent powers
No,
of the
see, their
High
submission has
Court?
been clearly this thing. National Council of the
And
petition
he is
has-
not the registered owner, over or above that.
I am not into that right now, my lord.
No, that is all right.
Unless
But
and
you see-
until I am allowed, my lord, I'll come to that, I'll satisfy your lordship.
No,
Because
482
my case is not covered by, my lord, MB Act, but it is covered by the Sales of Good Act 1930, my lord.
whatever it is, you see, like this petition.
Yes, my lord.
This is not
But
maintainable, Your
if there is any bar, my lord, I bow down, my lord. I bow
No,
down.
there is bar means what? You see, you cannot make the law to go the way you want. There is a prescribed procedure that has to be followed. Had it been rejected, okay, maybe a different issue.
My
Then
lord,
they
There
would
is no
have.
rejection. See the order.
my lord, I humbly submitted that fact, my
That is
lord.
all.
I am not
See,
hiding anything, my
Okay,
lord.
this court appreciates your honesty, but then cannot go beyond these things.
My
See
lord.
the order.
My lord,
Lordship,
in that case, that is my only
Section
this thing, my lord.
482
If my
subsection
lord is not inclined to, my lord, then my lord, I'll withdraw, my lord.
Yeah,
I'll
the
withdraw.
court is not relevant.
My lord, in that
You
case,
go, you first try
my
there.
lord, yes, yes. That was my only limited
See,
submission.
Mr. Thapa, that order dated 6/11/2000.
My lord.
You have gone through it.
Yes, yes, yes.
See, paying for my application with liberty to file a petition on the ground that there are errors in the application.
My lord,
Clearly allowed.
in the
Yes,
beginning
Now your
itself, my
submission
lord,
is something
I
else.
submitted to that, my lord. In fact,
Once
so
you
my
make a submission before certain authority, that will bind you.
which is why, my lord, I made this submission, my lord. If I cannot pass this hurdle, my lord, it's pointless for me to pursue the matter. So in that case, my lord, I may be allowed to withdraw, my lord.
That is better.
Section 482 is also very clear
He's
that when
withdrawing
inherent powers cannot be invoked.
Definitely.
My
This
lord,
court
even
is
in
not, no, we are going to.
in case of my lord,
You see, like that is not expected from counsel, like Mr. Gurung. You see,
Yes, exactly.
my lord,
not expected. This court did not expect that you will
Frivolous
move this.
cases
no,
are not
no, my
required
lord,
to be filed.
my lord, since Nongpo is too far, my lord, I made a feeble attempt, my lord. That is that, my lord.
You are a seasoned lawyer. See, Mr. Gurung, you are a senior man here.
Which is why, my lord, I made a very frank submission, my lord. Without it was, I came with a very clean hand, my lord.
Mr. Argun, learned counsel for the petitioner on instruction submits. The petitioner does not want to press this application and prays for withdrawal of the same.
With liberty to file afresh, my lord.
No, with
While that
liberty to
liberty
approach the
he has
appropriate.
to-
authority.
Yes, yes.
He's already taken the liberty down
The
there.
same with liberty to approach the appropriate. Stop.
Deeply offensive.
On prayer being made, this criminal petition. Wait, Mr. Gurung.
I'm sorry, my lord.
Court has not completed the order.
I'm sorry, my lord. My apologies.
On prayer being made, this criminal petition stands dismissed on withdrawal with the liberty as prayed for.
Deeply offensive.
With the liberty as prayed for.
Oblige you.
Item number 3.
May it please your lordship.
Yes.
Yeah, on behalf of the appellant, I'm filing.
So the affidavit has been filed, my lord, for the service of report on respondent number 3, my lord.
Hearing item number 3.
May I please, sir. My lord, this matter was heard on the last occasion.
It was heard by this
It
court.
was heard. And subsequently, matter was transferred to the Court of Chief and then returned here. In fact, in this case, what had happened that the petitioner hearing was, in fact, appointed as the.
What is the prayer in meeting?
In fact, the prayer is this, that we are challenging the impugn order that where I was, the managing committee has of the school had dismissed me that on the ground that.
Oh, you are
Yeah.
dismissal from service. You are challenging dismissal.
No,
from
we are
service.
not exactly challenging dismissal. That initially I was appointed in the school at.
The school is a government school.
Yeah, it's a upper primary under SSS scheme. Under SSS scheme.
SSS scheme.
SS scheme. So I was appointed.
So under the SMS scheme, there are number of teachers.
There are numbers.
Section post.
So number of teachers. So, but under the SS scheme, there are as per the CRC scheme that there are around 15 schools under the Mahendraganj CRC cluster resource. So within these 15 schools, the upper primary schools, each school has 3 teachers. Each school has teachers, English teachers, science teachers.
It is from Garo Hills.
From Garo Hills. So in fact, the teacher here, I was appointed as a teacher in the Malidas Para school. Then thereafter, what had happened that I was, as per the annexure 1, I was annexure 1.
Who are the respondents here? State.
State is respondent. Private respondent.
You are opposing or supporting his case?
My lord, I'm opposing, my lord. He is serving in 2 schools, my lord. He already switched over to another school.
So yourself and the state is on the same side. Yes.
So I was, as per the Annexure A, Annexure 1, page 14, I was appointed initially as a language teacher in the Kunar Ghati school, and I joined on April
Wait. Now your appointment is
1st
issued by.
April 2010
It is issued by
by the Respondent 7, that is
this managing committee.
managing committee of the school, Respondent number 7. Thereafter, what had happened?
Just a minute. Just let us go through it. You've been appointed as a language teacher.
Language teacher.
Now this letter has been issued on which date? 10th. 1st of
10th.
April. 1st of April 2010.
Yes, my lord.
Okay.
And thereafter, I joined the school. Subsequent to joining of my school, I had also completed the training teachers, that is induction training, that is at page 17, Annexure 4. There is an induction training which is a mandatory training for the teachers.
Wait.
After completing that training,
What is the Annexure 2? Annexure 2 is the
the Annexure 2 is the contract appointment.
You are Salim Khan.
Yes.
Now this has been issued which date? Annexure 2?
My lord.
The 1st of April.
Yes.
2010.
Yes.
On the same day.
My lord, understand.
Now this is an application for, this is an appointment for contract 59 days.
My lord.
Yes.
And thereafter, after that, I completed my induction training.
Who are the signatories down below?
My
This
lord.
Roy and Das. Why this? Who are they?
My lord.
At Annexure 2,
My
at the
lord.
bottom, before your signature, 2 names are mentioned.
Yeah.
Who are they?
My lord, they are the signatory that I shall not claim or have right over the appointment
That is
after.
the undertaking given by you.
Yes.
But the bottom, you signed at the bottom, isn't it?
Yes, my lord.
But then these 2 names, why these 2 names are there?
My lord, these 2 names are there signed duly by the school managing committee.
No, these are names only, nothing else.
They're just a name.
Have they signed as witness or what is this? What
Most
it would
probably,
imply?
most probably these has been signed as a witness.
So you are also not sure. Anyway, let us skip.
Now, then,
Anyway, no problem. See, like basically, we should understand the document.
my lord.
Anyway, it's okay. So here is an undertaking that you'll avoid by the terms and condition.
My lord.
Yes.
Then thereafter, I had undergone the induction training, which is mandatory, that is at Annexure 4. On completion of my name is it's reflected there, I had undergone the induction training. After that, what had happened that there was a verbal, I was allowed by the respondent number 6, on the basis of verbal order, I was allowed to join as assistant teacher in Malidaspara.
In a different school.
Different school. In a different school.
This has happened after the lapse of 59 days of your initial appointment.
Within a year.
Within a year. It
Within a
means well after 59 days.
Yes.
That contract was for 59 days.
My lord.
So that part is over.
That part is over.
Now you go to training at the time when that contract was subsisting.
My lord.
59 days subsisting. Then you complete trial on, sorry, training on which date? This training was for?
This training is induction training is basically meant for the upper primary school teachers, so as to increase the efficiency in the training.
It is training for how many days? Induction training. So
Yeah.
this is a training for at 9:30 a.m.
Yeah.
So it is implied that this is one day training on the same day.
Yeah.
Okay. Okay. Then what happens? You take part in the training.
Yes. After completion of training, thereafter, after
Then you
working,
do not go back to your school.
no,
That school.
no.
You come and join to a new school.
Yes. Thereafter, I was verbally asked by the respondent number 6, that is Cluster Resource Center, to join as assistant teacher in Malidas Para. Malidas Para is another school.
Cluster resource means state official.
Yes. Then accordingly, I joined.
You say as far as verbal instruction, you join.
Join.
Do they admit that fact or they deny?
My lord.
In their affidavit, have they
Yes.
replied to that?
They have admitted.
They have admitted.
They have.
No, we have denied it.
No. So on the basis of the verbal,
No, that is your
statement,
contention. We understand
Yeah.
that. Just for the purpose of appreciation,
Right.
there is no question code. You see, before hearing is completed,
Right.
we cannot say what contention will be accepted and what will be rejected.
Yes.
Now that is for just for determining the initial reaction. Now you say as per the verbal request of the respondent number 6, you go and join the new school.
Right.
Now whether this court wanted to know whether that part stands admitted or refuted. Now according to them that stands refuted.
Admitted.
Yes.
But then thereafter, white letter dated, that is
Where is that? By which thing you would join the new school?
that is at Annex 6.
This is Malidas Parabi
Yes.
SSS school. Now it says that it's a certificate, isn't it? And it says that you are doing duties in that site school till 1st June 2011.
Yes.
But then from which date?
Well, this I'm doing duty till date of 1st June 2002, August 6th August 2016.
Acha. Till the date of 1st June 2011 to acha. So language has a problem.
Yes, language is a problem. Yes, my lord.
Okay. So 1st June 2011 till 6th August.
My lord. Then what happened?
Then you left this job.
No, my lord. I haven't left. I'm still working there. But the only thing then thereafter what has happened, my lord, if you come to annexure.
Now see, this is again signed by the headmistress.
Yes,
Of the
headmistress Malidas Para Primary.
Well, so there is nothing to show that respondent number 6
My lord.
had any role in your joining in the new school.
My lord, that's what it is.
The document doesn't say it.
Document doesn't say. That document doesn't specify that. Then thereafter, what has happened that the my lord comes to the page 28. That is the type copy. The list of sanctioned posts under Maharagan CSC at the time of appointment. So, as per the list, in the CRC Maharagan, back to inform that there were 15 numbers of SSA.
You're referring to page 20.
20,
Annexure 7.
20A. 20 capital. That is the type copy.
20 is the type copy.
Yes, 20A.
20 is Xerox copy, I think.
Yeah, just copy. So it is not clear. So this has been typed properly at
Okay.
20 capital A.
Yes.
But that is the.
That is a communication by?
This is a communication by respondent number 6.
Yes.
Here it is mentioned that in the CRC Maharagan back to informed that there were 15 numbers of SSA upper primary school sanctioned in the year 2009-10. The following teachers were appointed by DMC against each school. So there are 15 numbers of school which comes under the
What is
Maharagan.
DMC? DMC means?
This is District Managing Committee. Under the
District?
District Managing Committee. Under
District managing committee. No. Managing coordinator or something like that.
sorry, I'm
District
sorry.
mission
District mission
coordinator.
committee. Sorry, district mission committee. So under this, there are 15 number of school, 15 number of school which comes under the cluster resource.
Yes.
Mahendragan.
What is your, where is school?
So
Your school?
my school where I had initially joined, that is at serial number 2.
And the school where you were joining at that relevant point of time?
At that relevant point of time, number 2. It is at serial number 2.
Konarghati. No. Initially you joined which school?
In a Konarghati. Initially I joined.
Now where is Malidas Pada?
It is. I'm coming to it.
Malidas Pada is there in the list?
Yeah, Malidas Para is that serial
number
number 10. But I'm coming to it. Yes. What has happened that when this list came out, my name was not there in the list.
In either of the schools?
Yeah.
Your name did not appear?
No. But my name was not there in the Konarghati SSA Upper Primary School. In place of my respondent number 9, Joinal Abdin was appointed. In my place.
No, but then on what basis you say?
My lord.
On what basis you say that in your place somebody has been appointed? Like?
My basis is this, that since I was verbally asked to work in Malidas Para, and this Joinal Abdin was working at Malidas Para, and when that list of sanctioned teachers came out, my name was not reflected in the Konarghati. In place of that, respondent number 9.
Joinal Abdin is a respondent here in
Yes,
this case?
Respondent.
Okay. He is represented?
He is represented.
By the managing,
Yes.
he will appear for both managing committee and...
Then thereafter, my lord, what has happened that I filed a complaint. Complaint was filed to respondent number 4. Then thereafter, letter dated 5/8/2016. This was the complaint is at Annexure 8.
No, this is a list of 6 June 2016.
Yes.
Now you joined that school.
Yes.
Malidas Para.
1st June 11.
11.
Yes.
So after 5 years this list comes.
This comes.
Your name is not there.
My name. Then
now you file a complaint on which date?
Complaint was filed on 5/8/2016. That is at Annexure 9, page 23.
What is Annexure 8?
Annexure 8 is this. This is a this is a complaint for. This is filed by me to the respondent number 5. Prayer for looking after the matter to give me as a sanction post.
This is written by you, isn't it?
Yes, even.
So this is, see, this is, here you say, what do you say in Annexure 8?
With reference to the subject cited above, I, Salim Khan, Assistant Teacher of Konarghati SSA Upper Primary School, do hereby inform Your Honor. I have been appointed as Assistant Teacher Konarghati SSA Upper Primary School in the year 1st April 2010 and also drawn 2 months salary from Tura DMC office. Continue my regarding service till one year. One day, the misunderstanding among our staff on the date of 15 June 11, uncertainly, I have been transferred in my new upper primary grade school at Malidas Para B SSA Upper Primary School. This school is recognized in the year 2011. Teachers of Malidas Para B SSA Upper, namely Joinal Abdin, transferred in my place. We both are transferred without any document. Either I have been in a section post, but now a day my service is shown in the UD this as SMC post. So kindly look after the matter and do the needful. And
what does it mean that nowadays that I have been in a sanction post, but nowadays my service is shown in the UDIS as SMC post? It means not under the Sharva Shiksha Abhijan.
Yes.
Isn't it?
Yes, ma'am. So this was an application given to the respondent number 5.
Yes.
Then thereafter, the letter dated Annexure 9, 5/8/2016, letter was issued by the respondent by the Joint District Mission Coordinator. It was issued to the respondent number 4. Respondent it was issued by the respondent number 4 to the secretary, that is respondent 7, to allow, wherein I was asked to allow me to. It was directed that.
What does it say with reference to the subject?
Yes.
What is the reinstate order? What is?
Otherwise, the sign to inform you.
Now, what is this? What did it mean? Reinstate order? Page 23, Annexure 9.
My lord.
What is subject? See under heading subject. What is reinstate order?
My lord, this subject means reinstate means I.
So
I am to
the
be,
question of reinstatement comes. You want to
Kunarghati.
Reinstatement comes when you are not in service. So the one position is clear that you are not in service at that point.
In fact, this is the reinstatement. So far, this language is written here, reinstatement, because
that is okay. You see, it is written here wrongly, reinstate.
Yes.
What you interpret it? What do you say here? If you say this is order asking your reinstatement, that means you were not in service on that particular.
Well, that is true, that reinstatement, but so far
you were not in service on that day.
I was in service.
So what is the question of reinstatement?
I was when I was transferred to the Malidaspara school. Then thereafter, when my name was not.
So this letter will help your case, or it will go against you?
Well, this letter will help on the basis, because this letter.
But if you take this thing, if you take help from this, then you have to go by that reinstatement. We cannot accept something partially.
Yes.
And reject something partially. See.
So on the basis of this, on the basis
let us read the order. Let us see. Why you do it half-heartedly? Let us read it. Let us try to gather what is there. He has to join Sri immediately. Otherwise, the undersigned will take action against the school managing committee. Now, this is a. Now,
and thereafter, in response to this letter,
whether this Joinal Abedin has filed an affidavit in this case?
Bharat.
Have they filed an affidavit in opposition? Yes. Okay. We will come to that. Your writ petition does not have any document which shows that Joinal was in fact transferred from Malidas to Kunarghati.
Well, at this.
It is only accept your averment.
Yeah, but
own statement. Nothing else is there.
Malad.
Isn't it?
Malad.
Your contention there that when you came to Malidaspara, Jainal was transferred to Kunarghati.
Yes, Kunarghati.
Is there any document to show it?
Malad.
Accept your statement. Is there anything to show?
In fact, there is nothing to show, but presently he is working.
That is all right. See, you can give your explanation.
Yes.
We are not stopping you from doing that.
Yes.
The question is that whether there exists a document or not. So answer is no.
Okay. Then thereafter, what has happened? The reply was there. At Annexure 10.
Yes.
That, reply by the respondent number 7, that is secretary, to the Joint District Mission, that in this reply that they have mentioned that with reference to subject cited above, we would like to inform you that the order of Salim Khan to join Kunarghati, on the basis of which he was transferred from his school, but in fact it is due to his irregularity, using headphones and misbehavior with assistant teacher Sikha Parveen in the school. He was terminated from his job, White Resolution number so and so, dated 20th/6/11, and in his place SMC appointed Sri Jainaluddin Abedin as assistant teacher in the school resolution copy.
So here its story is totally different.
Yes.
It is not that there was a interchange of teachers or transfer. You say that
some
you went to the
allegations.
other school and the teacher from other school came to your original school. Here it says no. You were terminated from service
This year, and which I have,
because of your misbehavior
my lord.
to certain extent that earlier annexure 8 also,
Yes,
where you yourself said that there is some sort of misbehavior.
my lord.
So you were terminated from the school.
My lord. It is there. And termination was done illegally.
So and thereafter this new person was appointed
Yes,
there. So it is not a case of transfer.
not a case of. Then thereafter, what had happened that is annexure 12. What is then thereafter? What had happened that the respondent number 5,
What is the line which is not visible here in this document?
which one? my lord?
That page 24, annexure 10. The subparagraph. So in this connection,
Ah,
is it legible?
what are this?
Page 24. Come to page 24.
Yes, yes, yes. So in this connection, we may therefore
Solicit your request to kindly revoke the
revoke the
reinstatement.
reinstatement.
You should have taken care of this. Should have given a type. copy
This
of
is in fact.
And then what happened? After
Then
this,
there-
then what happened?
Then thereafter, what happened that the
This resolution, this communication is under challenge by you.
well,
This is challenge. In
this is under challenge.
here is this petition.
Yeah, in the writ petition.
Okay.
Then thereafter, what had happened that the respondent number 5 issued a letter to respondent to the respondent number 7 school for conducting spot inquiry to conduct a spot inquiry. To conduct a spot inquiry.
So this letter was written after managing committee adopted a resolution to that.
Yes, well. To
29th August.
for conducting a
Then
The-
what
then
is this page
thereafter-
26? Page 26 is what? Annexure 11?
to conduct a
This
spot
is
inquiry.
again, you have a type copy of this,
Yes,
isn't it?
type copy is there.
Yes.
Type copy is there.
Yes.
So in this, where in para 4 down, it's mentioned that transfer of Hasim Ahmed from this is from so and so SSA up UPS to Patel Para and so. This is not relevant one. And termination of Sri Salim Khan by SMC Konarghati without proper procedure and approval. It was done without proper procedure approval.
Yes.
So,
Who writes it?
Pilot.
Who is the author of this letter?
This is by
District Mission Coordinator.
yes, madam. Then thereafter, accordingly,
Now, this is a communication of 2016, 1/8/2016,
madam.
prior to the resolution of the managing committee, the latest resolution,
Madam.
isn't it? The
Yes.
resolution came on 29th August
Yes, madam.
on the previous days.
Madam.
But then this letter is before that.
Before that,
Now it speaks about illegality of an action which was taken in 2011
madam.
after 5 years.
Yes, madam. Because the fact remains that
So suddenly this district mission coordinator, he woke up. He was sleeping, and suddenly he awoke and he wakes up and says that no. After 5 years, that no, that termination was not proper.
madam.
Any ground given why it was not proper?
They have basically mentioned that it was done without because I was not given the at the time of termination. I was not given the opportunity.
But then where is the approval of your appointment?
Madam.
Your approval of your appointment,
Madam.
except for that 59 days,
Madam.
there is nothing to show that your appointment was ever approved.
My lord, I'm coming to it.
Yes, tell us that.
I'm coming to it. Then thereafter, what had happened that the on the basis of the spot inquiry that was conducted, and where it was shown that my termination was without proper
What
procedure.
inquiry, when it was conducted?
This was conducted on 18/10/16.
After 5 years.
Because during that period I was
And what do you mean by spot inquiry?
spot inquiry in the sense that where the principal
They will go and they will recreate the situation.
no, but they have used this language, spot inquiry.
It is like a criminal case visiting place of occurrence, isn't it?
So if Marat comes to the at page,
Achha, then after this, where is the spot inquiry then?
I'll come to it, Marat.
And what is the list appended to this?
That is
See, this Joinal Abedin has joined on 1/7/2011. Now, this is very. If you see on the status report appointed 15 SSA upgraded school under Mahendraganj area during 2009-10. And then this fellow is appointed in 2011, his name figures there.
Yeah.
All others are, except for another one, 2011. Yes. How it is possible to include in a list of 2009-10 a person who joined in 2011?
That's what. That is the thing.
Anyway, then what happens?
So
in that list also your name is not there.
Not there, because it's not there. That is it. Then thereafter, on the basis of the...
Now you said about some spot inquiry.
Yes, spot inquiry.
Where is that the report of spot inquiry, or what is that? What basis you said there is a spot inquiry?
No, the basis is that at page 31. Typed copy is there.
Spot inquiry was held on?
It was conducted on 19/10/16.
1910 means in October?
Yes.
Now your letter at page 29, come to annexure 12. There is a confusion everywhere, confusion. Now this is a letter dated 18/2016. You got it, Mr. Khan?
I got it.
Now come to the body of what it says. With reference to the subject cited above, I am to inform you that the spot inquiry of such and such UP school regarding the revocation order of Sri Salim Khan, assistant teacher of such and such school, will be done on 18th October 2016. That means on the same day.
Got it.
The day on which it has been.
Yeah, but
and then you say, but then it was the next day.
But at page 31, the typed copy, it's mentioned the I Srimati so T.N. Marak BM zigzag.
You issue this notice for holding an inquiry on the same day.
Yes.
Now, what is the timing of issue of this notice and when this inquiry was held?
Inquiry was that the
no. What is the timing? Which way this court will determine all those things? These documents are apparently seems to be handiwork of some vested interest. This is something we do not know. Mr. Hazarika, if your officials are issuing this kind of things, we will call them. They will have to explain under what circumstances they will issue. We will make them liable. This cannot go on like this. After all, this government is paying.
Yes.
To the teachers who are appointed. It can't. Reading minutely all those
That's
things
true,
will
The
reveal
language
many
is very
things.
amb-
These are not, doesn't give you a very pleasant impression about the functioning.
that's true.
Okay. Then Annexure 13, they make a recommendation for your restatement, isn't it?
Yes, my lord.
And then what happens?
To be continued. Then thereafter, what thereafter, I had, on the basis of this, if my lord comes to the annexure, page 33, annexure 15.
Very surprising. 2011, somebody is ousted from service, and at the end of the 2016, recommendation has been made for reinstatement. Now, this reinstatement means was with all the benefits. Now, this 31, 29, then page 30. What is this 31? Now, this is a
These are the,
inquiry report.
yes, my lord.
Now, what is the proper procedure for transfer? At 6, serial 6, it says, without proper procedure, Sri Salim Khan has been transferred from Konarghati SSA UP school to Malidaspara school in place of Sri Jainal Abdin, who has been working as assistant teacher in Malidaspara so-and-so school.
My lord.
Now, what is the proper procedure of transfer?
My lord, the proper procedure is that in case of any teacher is transferred, then it has to be,
Any transfer policy, Mr. So far as this
my lord,
SSS schools are
yes,
teachers.
there is no
So far as the government schools are concerned, okay, we
Yes,
understand.
it is there. But
But then
SSS,
there
no.
is no such.
no such.
No such rule out there.
So when there is no policy, there cannot be a violation of anything, isn't it?
Correct.
Now, if you say correct, then it goes. If you say it is correct, then paragraph 6 goes. If you admit that, anyway,
In fact, there is no policy regarding transfer of this teacher.
then what happens?
Then after the order of reinstatement, then I had, as per annexure 15, I had filed in a page 33.
Page?
33.
What is this page 32 and 32A and all?
Well, this so far page 32 is, but the typed copy is at 32A, capital A. This letter is written from the district mission coordinator to the secretary, Kunarghati, respondent number 7, reinstatement order. With reference,
It is written to the secretary of the managing committee.
yes, secretary of the managing, that is the respondent number 7, the Kunarghati school.
Then what happens?
Then in this letter is mentioned that with reference to the subject side above and in pursuance of the inquiry report dated so and so submitted by block mission coordinator zigzag block, the undersigned is hereby directed to reinstate Salim Khan as an assistant teacher in the Kunarghati SSA Upper Primary School as sanctioned teacher, as sanctioned post, as a sanctioned post with a fixed pay of so and so, with effect from 14/12/16. This is a reinstatement order. Now, on the strength of this reinstatement order, I file an application before the secretary, that is respondent number 7, that is at page 33, requesting me to allow me to join in that sanction post on the basis of the order. And then thereafter, what had happened, Mala? Subsequent page, that is page 34, they had denied me of joining the school.
So you have written to district mission coordinator,
Yes. They had denied.
informing him about the denial of the
denial.
managing committee. Then what happens?
Then thereafter,
This is written on which date?
this is written on
2nd January
Mala,
2017.
2nd, 17. Then thereafter, on the basis of there was a communication letter from additional, that is district mission coordinator to the joint commission mission coordinator regarding the matter relating to the Konarghati school. With reference to the subject cited, I am forwarding a letter dated 2nd June 17 from Salim Khan which is self-explanatory. In this connection, you are requested to submit a detailed factual inquiry report on the matter and submit the same within a week to this office. Then thereafter, second inquiry. And the second inquiry was conducted by the same office. And the second inquiry was contradictory to the first inquiry. So we are challenging, earlier writ petition was filed, we had challenged the first inquiry. Subsequently, we withdrew and challenged this subsequent inquiry report. And the two
Earlier writ petition you filed challenge the?
Only the first inquiry.
Why first inquiry was in your favor?
We were asked to challenge the second inquiry report also, because the second inquiry report was.
But then why you came for first round of litigation? That inquiry report was in your favor.
Well,
so what was your cause of action in that?
No, our cause of action was that the first inquiry report was concerned, it was practically in our favor, and subsequently second inquiry was also conducted. So that's why we had to withdraw and then challenge the second inquiry report. Now the second inquiry report is contradictory to the first inquiry report. Since there is contradictory, we have in our prayer, we are challenging that for fresh inquiry. Because there are two contrary. One allows for reinstatement and the other.
Now before you come to that, you have to first give an impression to the court that your appointment or your claim of appointment to the post is a valid and legal claim. Now your selection under the SSS scheme, you have to show us which way you have been selected. The documents which you have pointed out, it goes to show that your initial induction in 2011 was for 59 days. First managing committee recommends your name and you are inducted on 59 days. Now what happens thereafter after 59 days, it is not clear. But then as per your contention that you go for a training, attend a training, and thereafter as per the Barwell request of resolution number 6, you join the other school. Okay. Now that is what, and you basically take shelter of one certificate wherein the period of your service in that school was shown. But then period of service in that school, whether it's on regular capacity or temporary basis, nothing could be made.
No. But only thing is
Now,
that the annexed.
If you even take shelter of that maybe you can establish a claim for appointment in that other school. What is that Malida school, whatever it is.
My claim is this: I should be reinstated.
You cannot make a claim to be appointed in the school of the managing committee here, the private respondent here, on the basis of that. Because after 59 days, your continuation in that school, if you are to continue there, it has to be on the strength of some legal or valid order. Where is that?
My lord, so far the
Where that other managing committee is also a party here? Mali,
Madam.
what is that? Mali, what is that school? There are two schools, isn't it?
Madam.
You are claiming appointment
Yes,
is
this was a party.
Kunar Ghati,
Yeah,
isn't it?
Malidas.
Now that the other school where you claim to have served for some times,
Madam.
whether they are also a party here?
Yes, madam. Respondent number 8.
Who is representing respondent number 8? Have they received notice?
My lord, as per the record, they have received, if I am not mistaken. So,
Well, if you say think, then you will confuse the court more.
no.
You have to say something with certainty. Of course, this matter is of 2020. It is expected that notice has been served.
Yes, madam.
But then, is there any order to proceed expertise against them? Mr. Snaitang for 7 and 9.
My lord.
Mr. Chanda will represent 7 and 9. That is the managing committee of the school where he is claiming appointment.
By order dated 6/6/22.
Yes.
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 If I may read out.
Yes.
It is also submitted by the learned counsel for the petitioner that respondent number 8 is not a necessary respondent and prays that he may be struck off from the area of party.
Is it? So thereafter it was struck off.
Accordingly, respondent number 9 and 7 and 9 are allowed further 2 weeks time to file their affidavit. And respondent number 8 to be struck from the area of party. Registry to make necessary correction.
Oh, that means struck. It is struck off. There is an order dated. What you said?
6/6/22.
So definitely that will weaken your case. There are two aspects, isn't it? Necessary
Right.
parties and proper parties.
My lord.
Now participation of all the parties are not always necessary, but
Yes,
then some participation is needed for
Proper adjudication. My lord.
You may not have any claiming is there.
That's
So in absence of then we cannot have any proper adjudication. And once you have chosen to strike their name off, then nothing remains for you. So your contention or claim with regards to that will go unproved. It will not be proved then.
basically our contention is this based on the NSA 32A where an order was passed for directing me to be reinstated in the Kunar Ghati SS as a sanction post.
On what basis? Each and order has some validity attached to it.
Yes.
Without any holding and selection process.
This is, of course, a
without
bare
any
order.
basis, just because one particular officer likes you and he said Mr. Ayub Khan should be appointed such and such.
But
Why should we? Especially this
Correct.
same order is not supported at this moment before this court by the state.
because the officials keeps on passing the order time to time, I think government would be in a better position to say
So
as to the
after
what
this
does the sanction.
2016 recommendation,
Alright.
you have not been taken into service.
No, Marat. I have not been taken to service in my original. I have been serving in Malidas. I have been serving
So till date you are serving Malidas.
in just Malidas. When there was an positive
why
order,
why you are claiming in this?
Marat, because this is my original appointment, and on the basis of the order where I was asked to
Your
reinstate
original
me as a
appointment was for 59 days. Now, if you say that you have a right to continue in that school, you have to show us something that beyond 59 days you have to. You just suddenly cannot jump to 2016 letter.
Yes. Only the thing is that since the order reflects about my sanction post in the original, so that sanction post,
See these orders, which says that you should be taken back
Marat.
to the service of such and such day. Nowhere says that at present you are serving in that Maladiv school. And you have chosen to strike out the name of respondent number 8. Anyway,
Marat, the only thing is now that since we have challenged my termination, and we have challenged also the two inquiry which are contradictory to each other. So we would, in my prayer, we have also stated that to set aside that my termination and for fresh inquiry to be conducted. If in case a fresh inquiry
and
is
if you are
conducted,
successful in this inquiry, then you should be taken back in service.
My lord,
which in fact you were appointed in 2011.
the
And after
inquiry,
13, 14 years,
yes, the
you will claim
inquiry,
back the service.
inquiry report will reveal as to what is the factual position as to my.
But then if it is in your own statement that you are continuing in some other school, why should you interfere? You carry on, continue in that school.
Well, the only thing is that my claim in the first place of appointment is that on the basis of the order, I
No,
ought
you
to
see,
have.
you were transferred and you willingly joined that other school. Now,
There
you
is
have
an
never raised any objection with regard to the transfer.
In fact, there
Then
was.
why should you come back to that school? Since you are continuing in that school where you have transferred, you continue there.
Basically, I am claiming on the sense that the place where I was working first is a sanctioned post based on the order. Of course, that justification as to how that sanctioned post, how I am in the sanctioned post. So that is the only ground which I am banking that I should be appointed in my first place of post appointment as a sanctioned post. So that is the.
But then you have lost.
That
You have lost that right once you have decided to join your transfer to the post of a transfer. That thing you cannot come back now. You have never challenged that.
Malad, the only thing is that because there was
Even if we assume that you were in service,
Yeah.
we do
There
not
is-
know whether
there-
you are continuing service.
there was an allegation regarding misbehavior.
That
So
you have admitted
that,
in your letter.
on the basis of that. So that was of the mind that I would come back again. But later on, in spite of I coming back again, the respondent number 9 was appointed in my place. So he ought not to have been appointed in my place when the order was that I should be given my reinstatement as a sanctioned post there. And the first inquiry report that reveals that I should be reinstated. And subsequent inquiry report is contradictory. So at this stage, since we have challenged those inquiry report, I am seeking direction from this Honorable Court that if fresh inquiry is to be conducted in the order of my reinstatement.
Enquiry to find out what?
Malat.
Enquiry to find out what?
Malat, since there are two inquiry, one is in my favor, other is in contradictory.
No, even they said, even why this first
Then-
inquiry was held, and why this second inquiry? What is the purpose of holding this inquiry? To find out what?
To find out the fact that
Inquiry
that
normally.
my appointment was busy. On the basis,
Normally, you see, whether you are appointed in a sanction post or not, that the government document itself good enough to show it. No inquiry is required to be held for that. Now say, okay, inquiry, there is allegation against you. And then to prove that we may have inquiry. But then there is nothing to show.
because
That, you see, that your discontinuation or this thing, you see, from that original school was because of that allegation against you till you took us to that annexure where you have by your own admission you said that there was some confusion with regard to your behavioral aspect. Now coming to the main order, the first order of your appointment, it is for 59 days, and thereafter whether you have a right to seek continuance, you have not brought us anything to show, except for these letters of 2016, which doesn't have any head and tail. We do not know on what basis these orders have been passed. So just because some officer passed some order, why should we be taken in service? It doesn't say that you were selected properly, you have been absorbed in proper sanction post, and then you have been thrown out from there. Nothing.
I think the government will be in a better position to.
Government will have to explain definitely about
Yes.
these two contradictory.
Yes, because
But then
these letters have been issued.
you
so
see, like the
government
one
will
thing
be in
is
a
that
better
you see,
position
you
to
cannot
take.
establish case on the weakness of other side. It seems like some officers they have behaved the way they want. If they are against you, they will pass order against you. If they are in your favor, they will not pass order. That is what these thing reveals. So otherwise, what is the justification of so many things? There one inquiry officer who holds an inquiry finds an inquiry in your
Same
favor.
inquiry officer.
Subsequently, same officer holding the same inquiry
Same
finds the inquiry against you. So
that's
which way it will interpret?
That's what I think the government would be in a better position to.
So that is what your case is.
My case is this.
Yes, Mr. Hajarika, just justify your inquiry and all, and what propelled you to pass that 2016 orders, reinstating him. And if you say this officer has been done, you can take your seat, Mr. Khan.
Well,
We'll come back to you if required.
Yeah, my lord.
And if you say this officer is done in his individual capacity, then you have to tell us what action you have taken against this officer.
Here, my lord, what happened in 2010? He was appointed for 59 days.
Yes.
Thereafter, there is no appointment order in favor of the petitioner to continue in the service.
Correct.
Meanwhile, some misconduct on the behalf of the petitioner, he was again terminated from service.
If he is not continuing beyond 59 days, why should he be terminated? What is the requirement?
No, I am coming to that. Here, question, it is rightly your lordship has pointed out, why it may be after 59 days he was continuing without any.
See, the maybe is not a thing. If you
No,
say,
yes.
see, whether a person is continuing,
Yes,
there or not,
yes,
he must be knowing it. You being the approving authority, if at all you have approved somebody's appointment,
appointing
or otherwise you just say that this is appointment by managing committee,
yes,
then why you have given the 59 days approval?
no. Here is,
The 59 days approval is by you, not by managing committee.
no, it is initial in the 2010 in the SSS school. Initially they are giving 1 year appointment with a minimum salary of 3,000. Previous that 1,500, my lord. 3,000 with a condition he will continue, and it is satisfied, then his service managing committee will continue his service. It is both sides, managing committee and joint district mission coordinator, jointly they have signed in the contract. In initial
See,
appointment.
managing committee cannot bind your action.
Yes.
It is not required.
Yes, yes. It is
You may not go by what they say.
Yes.
Except for recommendation of candidates and all.
Yes.
Now they may recommend one name. You find that person is suitable, you approve it.
Yes.
If you find that that person is not
Yes.
suitable,
No,
you can
not
reject
suitable,
it
it
by
is.
giving your reason.
Yes.
Isn't it?
Yes.
Now, basically, managing committee cannot bind you.
Yes.
Okay. The whether to approve some appointment or not, that is up to you,
Yes.
provided you are satisfied.
Yes.
Now, here it's a case where you approved the appointment for 59 days. Now, what happened after the lapse of 59 days?
Yes.
What
Yeah.
happened? After the lapse, this 59 days lapse,
Yes.
whether the petitioner was still in service?
No, in that case, my lord, I beg to state that thereafter the managing committee has not forwarded his name for necessary approval to this office, my lord. So we are ignorant about it, my lord.
So, according to you,
Yes.
so far as the state is concerned,
Yes.
your submission will be that after 59 days there is no continuation of service.
No.
So far
No
as you are
communication.
concerned.
We cannot say.
Now
because-
there may be continuation,
Yes.
but then that continuation was strictly under the managing committee.
Yes. Because after 59
If this, say supposing,
Yes.
if that continuation is under managing committee,
Yes.
then terms and conditions of that service
Yes.
will be regulated strictly by the private terms. Writ petition will not be maintained to enforce it. Yeah.
But here.
Because government is out of picture.
Yes. Yes.
Then
Yes.
managing committee will not come within the definition of Article 12 except
Yes,
for the
yes.
duty with discharges.
Yes. Yes.
It's public duty.
Yes.
But then appointment has nothing to do with public duty. It's a contractual thing
Yeah. Context.
between them.
Yes.
So for that purpose, writ petition will not be maintainable. Anyway, just continue.
And thereafter, my lord.
So according to you,
Yes.
after that expiry of 59 days,
Yes.
there is no constant continuation or extension of service of the petition.
There is no. I cannot say there is no communication.
By the government, by the government.
Ah.
We're talking about by the government.
Ah. Yes.
Other aspect managing committee is there, we'll go to them after you finish.
Yes. Yes. Yes, ma'am.
So we can record it here
Yes.
that you submit that after 59 days, the government doesn't know what was the status of
Yes.
the
Yes.
appointment.
Yes.
There is no extension.
Yes.
And so far as the transfer part is concerned,
Yes.
which the petitioner has submitted,
Yes.
that on the instruction of respondent number 6,
Yes.
the petitioner has joined the new school.
Yes.
What do you say there? That also you do not know.
No. Here, my lord, there is no record.
There is a specific averment, Mr. Khan, with regard to that on the instruction of Restaurant number 6, you have joined the new school.
Yes, yes.
And what is the reply of that averment by them, by the state?
Para 5.
Affidavit filed by respondent number 6 will make it clear, madam.
Yes.
Affidavit filed by respondent number 6. In para 6,
Restaurant number 6 has filed a separate affidavit.
Yes, sir.
coordinator.
He's a party by name.
My lord.
Yes. Yes.
The affidavit filed by respondent number 6.
Yes.
Restaurant number 6 is not a party by name.
Yes, ma'am. Not by name.
Coordinator cluster resource center.
Yes, so he has filed a separate. Now this coordinator cluster resource center is not under the project director.
It is under the director, madam.
So they should come under the same thing, but then he has filed a separate affidavit.
No,
And
no.
how many affidavit has been filed
No,
by the state?
here, my lord, here is cluster in the block level, my lord. That is the reason they are not coming to the government.
That they are not under this thing. Oh.
No, my lord.
Cluster
They are-
coordinator, he is not under this thing. He is not a government.
No, my lord. Because one of the teachers.
So who appoint? Wait, just a minute,
Yes.
Mr. Hajarika, you'll have to make us understand. This coordinator of cluster resource center is a private individual.
No, here, my lord, it
He's
is.
not a he's not a government individual.
He is
he's not
the
a government
government LP school teachers, just to look after some.
No, this coordinator, whether he is a government servant or he is a private person,
No, he is a government servant.
then
He is the government servant in the government
whatever it is,
LP
but then
school.
he is under respond number
but
one.
he
They
has-
all come within the definition of state, under the state.
Yes, under state.
Then that is what. So, but even as see,
Yes.
coordinator has filed a separate affidavit.
Yes.
Does it mean that he has a different stand other than what the state has taken?
Yes.
We have to come to your
Because
affidavit.
only specific allegation in
If
his name. that-
petitioner fails to make out a case of its own, I think you will make him a case for it. These are initial reaction. Do not go by this.
No, here, my lord, what happened? He is the government LP school teachers. He was appointed as a cluster resource center, this thing, to look after this school and giving some report. That is the thing for cluster.
The coordinator, the
Yes,
resort number
coordinator.
6.
Yes, coordinator.
So he has no authority to direct transfer anybody's.
No. He has got no.
Where you have said so?
No. I am coming to the that affidavit filed by respondent number 6.
Now, just a minute. The first, let us see what is the affidavit of opposition of resort number 2.
Para 5 of respondent number 2.
Mr. Khan, we'll come back to you.
Okay.
Let him place the case in his way, and then you will definitely have a right to reply. It is an affidavit on behalf of the respondent number 2, or for all the respondents. Only on behalf of respondent number 2.
All the state respondent.
But then it is on behalf of the respondent number 2. That is what is written here. You never said you have been authorized to swear in affidavit on behalf of all the respondents.
May I pray, my lord, matter may be come after 2 days, so I will get more clarification from the officer concerned, my lord.
The thing is that, Mr. Hajarika, once we stop hearing, discontinue, get it.
Okay, my lord.
So after a few
Yes,
days,
yes.
then the court loses everything. Nothing, court remembers nothing. Now you say somewhere that managing committee of the school is the sole authority of SSS school teacher
Yes.
for their own this thing.
Yes.
So you want to say that it's the managing committee who will appoint
Yes.
SSS teacher.
Yes. Not
No
the
approval from the state is needed.
No, approval is required. We are the approval authority.
So why do you say sole authority? Come to page 6 of
Yes,
your
yes.
affidavit.
Yes, my
On
lord.
the
it
page
is-
5, page 5. Page 5 your affidavit. On the top, the deponent further begs to submit that all SSA, LP and EP schools have their own independent school managing committee, and the school managing committee is the sole appointing authority of SSA school. Teachers for their own school only. Thereby the question of transfer does not arise.
Now, I meant to say that they are the appointing authority and we are the approval authority.
What you say? What is the difference between appointing authority and a sole appointing authority?
Sole means I mean to say
Once
that
you
only
say sole appointing authority, what emphasis it will carry?
that is only these people are the managing committee are the appointing authority.
Basically, you want to say once you
Yes,
prefix
that wording is
that would give an impression
Yes,
that
yes.
authority of appointment is confined to one person.
yes.
That is-
That is there is
Once
some,
you say sole,
I beg
if
to-
you say the appointing
yes.
authority, okay, we may say there
I-
is some.
that wording is something.
Anyway,
Right.
the fact remains that you said that you are not responsible for transfer and all those things. You
Yes.
do not know anything.
Yes, yes.
Filed a rejoinder. No rejoinder have been filed. Have you filed any rejoinder against the affidavit of this state? What is your reaction to that inquiry report? What is your response to that inquiry report?
Inquiry report, it is done in 2017, my lord, and only the finding
No,
that
why you have inquiry? See, one way you disown
yes,
that you have any role in transfer.
yes, yes.
You say here that the
Yes,
transfer of the petitioner
yes,
from one
yeah.
school to another school
I am after
is an
going through, yes.
internal matter of the managing
Yes,
committee of
my
the
lord.
school concerned, and you have no hand in it.
Yes, but
Okay.
it may be,
Then in 2016, what propelled you to order some inquiry? Why you have ordered some inquiry?
here, my lord.
See, you cannot maintain two arguments. One is that
Yes,
after 59 days,
Yes.
petitioner service was not extended. So as such, she was
extended or
no more a
not,
student
we have
under
no knowledge
government.
about it. Yes, yes.
And at the same time, you ordered an inquiry in 2016 to find out the truth behind termination of the service of the.
Yes.
So that action shows that petitioner was under you. Otherwise, why you hold an inquiry?
Yes, it is.
So then it's okay. Then the petitioner has a case
Because
then.
an inquiry report is not directly telling that he may be.
The fact that you have decided to hold one inquiry, will it not go to show that the petitioner service was under your control?
And
Once you, after holding inquiry, you issue an order saying that the person should be reinstated, will it not show
yes,
that
it
you
shows.
claim to have some
We are
control
admitted,
over?
my lord. We are admitted.
So that
it
means
is,
you see, you cannot
Here
maintain two arguments. One is that discontinuation of automatic discontinuation after 15 days,
No.
and at the same time you hold an inquiry
Yes, because
into the alleged termination.
that inquiry may be purposely this is on the complaint of the parties. So
It can be on the basis of anything.
No, that is
It can be on the basis of anything. If a person is not under your control, Why should you hold inquiry?
Yes.
And why should you pass
That is-
this order?
I am admitted, my lord. That is
So your
officer concern
admission
is,
would go to show
yes.
the
Officer
petitioner
concern
was
is-
petitioner service was under
yes,
you.
is in fault. That is I admit.
The petitioner service was under you. You admit that much?
No.
Why not? Then why you have held an inquiry? See, basically your affidavit is evasive. It's neither here nor there. Okay. Your assertion made here, you see, does not show anything concrete so far as your stand is concerned. You have to explain us at least one thing, that if it is your case that after expiry of 59 days, petitioner had no right of claim of appointment under you, then what propelled you to hold one inquiry in 2016? Inquiry into the hard termination.
It is there. It is there.
No, what? Then tell us the reason why you have held.
Here, my lord, this one they are not going deep into this matter and not following the due procedure of law, just on the basis of the complaint.
It is none of your concern. What is the due process of law?
It is not our concern.
You did not know that what is petitioner service condition.
Yes.
Because you disown her service after 59 days.
Yes.
You say, no, we are no more existing service provider.
Yes. But they have done.
If at all the petitioner has continued, this is totally under the managing committee.
Yes.
And their own understanding.
Yes.
Then what right you have
No.
to hold an inquiry and come and say that termination was not according to the procedure?
Here,
You
my
cannot
Yes,
maintain
no,
two
I
arguments.
understood, my lord.
Please maintain one set of
officer
arguments.
concern is in the fault for not making proper
Who was that? fault?
that inquiry officer. They have conducted the inquiry as officer without saying.
See, role of inquiry officer comes once he has been asked to do inquiry.
Yes.
But then the superior officer must have directed him to hold
district mission
inquiry.
coordinator.
Now, when a superior officer holds an inquiry,
Yeah.
today, say supposing somebody is serving in a private concern, will government official go and order inquiry?
Yes.
Can they order inquiry into the service related things?
Yes. my lord.
Until and unless government has a stake over this thing.
Yes.
So how can you maintain these two arguments? Just tell us.
That is very difficult.
You have to disown at least one of the argument.
Yes.
Either you say that the continuation beyond 59 days is with your approval, or you say this inquiry should not has been held and it was done by the
Yes,
officers
by-
totally in their personal capacity.
Yes,
But then
yes.
that stand you have to take.
Yes.
We are just telling about
Yes,
the options which
that is the thing.
then
That is the thing. Inquiry has supposed not to be done by the
then
government.
what reply shall we record here? So far as you are concerned.
Concern
Give
means they have done this inquiry on their personal.
So what
capacity.
action you have taken against them?
Personal capacity.
No, what action you have taken against
Because
them?
higher authority has not taken any action in this regard.
So how do you allow a person to do those things, officers to do it? How do you allow them to go scot free? They will do whatever they like.
Yes, yes,
That government jobs become their personal property.
yes. There is some mistake is there by maybe bona fide mistake, my lord. From their
Bona fide
part,
mistake.
without
This kind of mistakes are bona fide mistake.
no,
Now
there
you
is-
see, one inquiry holds
Yes, my lord.
the things in support of the petitioner.
Mm.
Subsequently, there is a change of mind, and the same officer holds another inquiry and goes against him.
Yes,
And then you say everything is done in good faith. It's a bona fide action.
yes, good faith.
Okay, will not. How can that be there? You see, I do not know how you are still maintaining two arguments. You do not know.
In this
At
regard,
least
my
you
lord,
should choose one of the things.
no, in this
See,
regard,
make
my-
sure at least none of your submission should bring trouble to the authority concerned.
Yes, my lord. No, in this respect, my lord, I may be allowed to get clarification in this point, my lord, because in the affidavit they have not clarified in respect of the inquiry, not clarified properly, my lord. So I may be allowed, my lord, 2 weeks. I will file clarification.
It is a 2020 matter.
Yes, my lord.
Okay,
Okay.
at least
Inquiry
what
report.
stand you should take,
Yes.
what you should not take,
Yes.
that is for
Yes.
you to decide.
Yes. So
Okay.
I may
But
be
then you
wrong.
cannot maintain two contradictory statements.
Yes, and that is I am admitted, my lord.
Okay.
Yes.
But then so far
So-
as till now your submission is concerned,
Yes,
you are not disowning anything. Neither
yes,
you are saying that continuation beyond 59 days is at your instance,
yes, yes,
nor you are saying
yes.
taking a clear-cut stand with regard to the inquiry.
Encourage.
If you say it is
Yes.
in good faith, then after holding one inquiry, why do you have another inquiry?
Okay, my lord.
Mistake can happen once.
Yes, my lord.
How can it be repeated?
That is there, my lord. Because same person requires same matter and two different views.
What is your answer? You see, that is there. We can see.
No,
But then how do you defend that action? That is the main thing.
Yes, yes. That is the reason, my lord. I will sought the clarification from the concerned officer, my lord.
Yes,
And-
managing committee. What do you say?
His appointment was, he was appointed on a purely.
Just Mr. Hazarika, just hold on for a moment. Let us see what. If you can get some more clarification, further clarification.
He was initially appointed in the year 2010, my lord, solely on temporary basis, my lord. Thereafter, my lord, in the year 2011,
Temporary basis means like you are not disputing that 15 days appointment.
my lord, no.
So what do you say that his tenure ended after the expiry of the 15 days?
No, my lord, he continued till the year 2011, my lord, and my lord, without,
That is beyond period of 15 days.
my lord, my lord,
Now his continuation was on the strength of.
my lord, because the managing committee had issued the appointment letter for a period of 1 year, my lord, and based, my lord, if I may take your lordship to the
Initial order.
initial order, my lord.
You see,
And that was purely temporary basis, my lord, and subject
then what is the meaning or relevancy of this second order of approval for 15 days?
my lord, that was issued
If
by
your order, first order for 1 year is to prevail, then what would be the interpretation of presence of the second order for 15 days?
that,
Will
my
it
lord,
have an effect on the initial appointment by the managing committee? How a person can be appointed twice under two different conditions in one post?
my lord, the order of the government will prevail, my lord, in that regard, my lord.
Now you also do not have a stand. You see, it is a compelling situation where you have
my
to
lord-
say,
but my lord-
apply your legal brain and try to give a necessary
My lord, both
interpretation
ways, my
of
lord,
things.
either both ways, my lord, but
Now the thing is that, see, if a person is appointed under SSS scheme,
my lord,
salary will come from the government if it is in sanction post, and if it is purely by the managing committee will pay. Now the government order says that it was for 59 days. Let us assume that salary for 59 days was paid by the government. Now what of the rest of the period? You paid it by yourself.
my lord, the funds from the school, my lord, because his was a post as a
So,
floor teacher, my lord. It was
Can we know the
temporary-
details
temporary
on
post,
which
my lord.
can we know the details if these other things are not revealing the status of the petitioner at that point of time? Can we get the details of all those things? The salary structures also which are prevailing. Will it be possible? Will it make our work easy, or will it make our work more complicated?
Quite follow, my lord. What?
See, Mr. Chando, what matters is that you must maintain one stand. You cannot maintain two different and contradictory stands. Here, our effort is to find out what was the status of the petitioner so far as this
So
appointment
far
is
as the
concerned.
status is concerned, my lord, his
Now, his claim is
temporary,
basically
my lord,
for his
temporary
reinstatement.
my lord. He, my lord,
Yes.
without informing the school authorities, he went ahead and on his own volition, my lord, he joined the school of the respondent
No,
number 8, my lord.
that
without
is a
informing.
different thing. But then your stand is that he misbehaved with somebody
My lord, that
and
is-
you have
that is also there, my
terminated.
lord. That is also
So
there, my lord. Coupled with the
after
fact,
his
my lord.
termination, whatever he does, you do not have any say on that.
My lord,
So again, here becomes another thing. You see, he of his own, after you terminate, what option he has? You will go and join
my
somewhere
lord, he
else.
joined, then only, my lord, the termination came, my lord. I can substantiate that, my lord.
No, but then if you say his termination is based on some behavioral aspect,
And it was only
Okay.
after he joined the school of the respondent number
then
8,
how
my
come
lord.
the allegation of misbehaving
It
comes
was
then?
all along, my lord.
So that
the
means
school
your
had been
entire
receiving
allegation is wrong.
The thing, my lord, the school had been receiving the.
You want to say you have taken a vindictive action because he has joined some other school without informing you.
No, my lord.
after you take this thing, especially allegation contains misbehavior with a lady teacher, as the name suggests, and that you say that happened after he joined the new school.
It was, my lord, during his tenure, my lord.
Things are not clear, you see, neither this side nor that side. These are the cases where basically you need some sort of investigating agency to find out the truth. It's very difficult for a court to find out the truth, especially when the parties are not open.
In fact, my lord, the second inquiry report is clear, my lord, on this aspect, my lord, about his appointment.
Why
and everything, my
inquiry
lord.
should be held?
Lord, this is the state, my lord, who has
If see,
done this inquiry, my
two
lord.
things. If his appointment was for 59 days, after 59 days, if there is no extension, appointment goes. He will not be deemed in service of the school. But then now if you say that he has been terminated, that means that will prove that he was continuing in the school. Now in such a case, you have to show us he was continuing in what capacity. Whether as a teacher purely under the managing committee or as a teacher under the SSS scheme. You cannot maintain two things, that expiry of appointment and termination, which took much later after the expiry of 59 days. You got it?
My lord.
Now, second thing is that if a person is not continuing under SSS scheme, assuming that he was continuing in any of the school, how can his termination and inquiry thereafter be held by a government authority?
It was, my lord.
Will it not go to show that petitioner is in service?
He was not in service, my lord.
That is all by implication. That is all
shown.
by interpretation and implication. Okay. At least the petitioner also has failed to bring in anything on record to show that he was continuing and in what capacity he was continuing. Now, if you go by the law, burden of proof lies with him. Definitely. But then your action must have some clarity. Instead of throwing any light in the matter,
whether he was under the managing committee or, my lord, under the SSC, my lord, I'll seek my lord. I'll seek and I'll.
We'll be needing. You see, this entire writ petition and the averments.
That will make the matter clear, my lord.
Now, state's affidavit one way disowns the continuation of the service after the expiry of 59 days. That is what Mr. Hazarika has said, what their affidavit also shows, what this court would gather. But then there is nothing to show what propelled them to have this inquiry. If they say that somebody is not functioning under us, under our control, what right they have to hold an inquiry? You have seen the affidavit of the state.
My lord, we have not been till date, my lord, we have not been served with.
Without that, how you are arguing a case?
I've been
Where there is a total contradiction of stands.
I've requested. They said, my lord, they will be supplying as a copy.
That is for you, you see, like this. But then this court was under impression that you know the contention of the state. They do not say anything about the legality or validity of the inquiry report. What they say, that inquiry report contradicts itself. That means it goes to the merit of the inquiry. So far as the legality of the inquiry is concerned, that stands.
They are silent.
Until and unless they say that it is that specifically done by that officer in his particular thing. But then their stand doesn't say so. You have a copy of this thing if you want to see. You have to maintain a stand. Until and unless they take a stand, it's very difficult for the court.
Limited action, my lord. I'll seek instructions, my lord, clarifications, and I'll place it.
The problem is that, Mr. Chanda, once you give time to one thing, once you are very near to decide a matter.
My lord, may fix it after 2 days, my lord. We'll have instructions taken, my lord, and we can place it before your lordship.
Mr. Hazarika also would be needing time, and then the government official, he will ask for inquiry, and then may not come, instruction may not come in time. This is a huge confusion. If somebody is continuing under the government must be paying that person's salary, then everything will be reflected in the records of the department. Nothing is there. I do not know what is the difficulty. Mr. Hazarike, your affidavit also has left everything on the implication. The way you have narrated your version of the story, there is no specific denial. Only thing is that if that be the so, then why petitioner did not do this, why petitioner did not do these things. If you have denied something, you say we deny. If you accept something, you say we accept. Why it has to be something like that? You do not at all deny those facts that he continued in the school for 1 year and then joined this Malidas Pada school on his own.
No.
Come to page 7.
No, as per this writ petition, as they have mentioned, so
you have repeated that. That is, you should have denied those facts or should have accepted that fact. You are neither here known that. What you say, only last line say, if it is so, why the petitioner has not challenged the alleged termination order. So the court will, by reading the last line, the court will have to first make an understanding that the earlier part of the narration, basically it is denied, it is not right.
Okay.
Now you have to justify the holding of the inquiry. You do not say that this person condemned without authority or without any approval, he has held the inquiry. There is nothing, you do not.
I have gone through my notes. I know there is some defect out there.
What is your affidavit, Mr. Chanda? What is your version of the story? Let us see, before you have a definite concrete set of instruction, let us first see what would be more required. What is the respondent number 6? Is he the person who held this holds this inquiry? No.
No.
Respondent number 6 is the cluster coordinator.
Why he has filed a separate affidavit?
Because he has only the limited thing, my lord.
He had a limited role to play.
Very limited role.
In the petition in para 5, my lord, petitioner says, my lord, specifically that it is on the verbal instruction of respondent number 6, he had joined the Maldispara school, my lord.
No, if it stands admitted, then that will stand.
Denies, my lord. Respondent number 6 clearly denies, my lord, in his affidavit, my lord. If I may.
But then what about the respondent number 2?
Respondent number 2, my lord.
There is no specific denial. That is what this court was pointing out to Mr. Hazarika just now. They say if that be the this, then that be the this, then why petitioner did not do this? You see, there is a way to reply. You see, the law says that there should not be an evasive, reply. That has to be specific.
They say, my lord, they are not the one. They have not done anything. They keep quiet, my lord.
They have made a averment in writ petition para 5.
Para 5, my lord.
And what is the reply of that? Para 5? By this respondent number 6, you said?
My lord, has no comment to make, my lord.
Then? That means what? Silence means admission.
Again in my lord, para 6, my lord, they clearly say, my lord, that they have never issued any such kind of verbal instructions to the petitioner, my lord. page 4, my lord. If I may read, my lord, it is
Of
further
page 4 of
4 of affidavit filed by respondent number 6, my lord.
just a minute, just hold a minute, just a minute, just let us just see what is written in previous paragraph. At least one thing he says that there is nothing on the record to show that transfer order was issued by the cluster resource center. Now here you say in this affidavit again it says that petitioner was appointed on contractual basis for 1 year.
1 year, my lord. Contractual
that
basis. That
59 days goes.
My lord, goes, my lord.
So that order is irrelevant.
State will be, my lord.
See, this first order is by the managing committee, 1 year, and 59 days by the state.
State, my lord.
What will have primacy? Now, see here he says, you see, he says the certain things. You said that he was transferred to some other school. Now you said that he joined that school without your consent,
My lord.
and the determination took subsequently. Now, but then if you come to the response number 6 things, affidavit, come to page 4.
Oh, my lord.
At the bottom part, the petitioner was transferred. See the fourth line from below. The petitioner was transferred to another school. You got it?
Page 4, my lord.
Page 4 of the affidavit filed by the number 6.
Yes, my lord. The petitioner was transferred to another school, that is so and so and so, and joined the post and continue his service in the said school. However, on the contrary, the managing committee of SSA UP school says the petitioner was terminated from his. So it is there, my lord. It is there.
So that goes. That means it doesn't say neither nor here. You say you have terminated. So that is what you say. It's not correct then.
Otherwise, also, my lord, contractual employees, whether they have the right to, my lord, agitate their employment, my lord, that is the question which is to be decided by this honorable court, my lord.
Which affidavit will have primacy? The response number 2 or response number 6? Yes, Mr. Hajarika.
Yes.
What is to be done?
But in fact, my lord, if you go in general, my lord, not in technicality for these two inquiry reports, that he has no.
You want to say this inquiry report is a mere outcome of technicality?
No, my lord. It is.
That is what makes the case.
Yes.
Otherwise, petitioner has no case.
So, yes, Only these two inquiry report they are making contradictory with each other, my lord. So I require some.
We may not go to the substance.
Yes.
We would say,
Yes. No.
we would like to put a query to you.
Yes.
If you disown the service of the petitioner
Yes.
beyond that period of 15 days,
Yes.
why you have made an inquiry to the termination?
Yes. What is the
That also not
requirement
once
of
or
the state
twice.
to make
Now
that?
please reply us this.
Okay, ma'am.
If a person is not under you,
Yes.
why should you have an inquiry?
Yes.
And why should you have an inquiry and direct the managing committee to reinstate?
In that respect, my lord, I respectfully submitted that I required some instruction from the concerned officer, district mission coordinator, who has given the order for inquiry. For what reason? Maybe some other reason behind it.
Things
So
are
it may be in the office.
things are not well in your department, it seems.
Myself also, I guess like that.
You should
But
use
anyway,
your good office and advise the
because it is
department.
my duty to get the clarification.
See, this way somebody will end up in trouble.
Anyway, I have to get.
This will not be a very pleasing experience for neither of us.
This is all.
Yes, let him take clarification on that part. At least satisfy us how he can hold an inquiry. If at all, if it is their claim that you were not under them after the expiry of 15 days.
Correct.
But then why you have deleted the name of respondent number 8? That may go against you. Well, heard the learned counsel for the parties. Mr. Chando, you also have the necessary instruction. Please clarify the things.
Instructions taken on.
Learned counsel will just. Mr. Hajar, learned GA appearing for the state, as well as Mr. Chanda, learned counsel appearing for respondent number 7 and 9. Praise for grant of some more time to obtain. Praise for grant of some time to obtain some more instruction in the matter. The prayer has not been opposed by the learned counsel for the petitioner. Prayer allowed. 1 week.
After 3 weeks, my lord.
No, this will be too long.
Also,
No, do not try to avoid this
No,
thing. That will not do this thing. You see, it will only result in wastage of our time.
yes. Election is over.
That will not help your thing.
Yes. Okay. No problem.
Why election is still, you have a problem with election?
No. Election is over, so.
Okay, we'll give you 2 weeks then.
Okay.
2 weeks.
Item number 4.
Must.
1 minute. Yes.
No, my lord, the police have registered an FIR under section 500 of the IPC, which I concede is not permissible. My lord, there is a judgment of our own honorable High Court. But my lord, on the plea that the entire FIR should be questionable, I have some reservations. I just want to argue this matter. Because my
So
FIR does not talk only about
So
defamation.
we'll have it in the second half. There is no problem.
Lordship, we have some difficulties, Lordship. Seniors not.
Yes. So what happened?
Lordship, the council is having some difficulties, Lordship.
When do you want it?
The next 1 week, Lordship, 2 weeks.
What do you want to say?
My lord, what I want to say, my lord, is, my lord, there is a judgment of our one honorable High Court. In fact, criminal petition number 12 of 2018, which supports his case, which I fairly consider, my lord, that is the law. But what I say is, my lord, if you lordship will read the FIR does not talk only about defamation. The FIR talks about cheating, my lord. Now, if the police registered a case under the wrong section of law, my lord, I as a litigant should not suffer.
What can we do? Can we alter the charge at this stage?
My lord, actually, my lord, the case is still under investigation. Had the police charged it under section 500, then my lord, I would
If
have
you
not said
concede, you
anything.
file a fresh FIR. That will not be deterred. But the res judicata will not be applicable there.
No, my lord, in fact, my lord, what my
The
submission...
question of double jeopardy also may not come if there is trial is not being held.
My lord, had the charge sheet been filed, my lord, it would have been a different thing altogether. But my lord, the matter is pending investigation. Lordship, it passes.
Once you concede a thing, thereafter, is there any scope of keeping the thing?
No, I'm not. I'm conceding on
until and unless prosecution comes with something. You are not.
I can just please the law, my lord. Just please the law.
Okay.
Because my lord, 500, of course, I have to as an officer of the court. My lord.
Mr. Snaitang is asking for time.
Yes, my lord.
You have no objection to the grant of time, isn't it?
I don't have any objection.
You agree with what he says?
Lordship,
we agree with Mr. Gautam's submission or not?
On the strength of the court order, Lordship, this case has been registered under section 500. 500, the allegation.
On the strength of the court's order.
There is
that
the
also
court.
will not be permissible, my lord. No, what my
500
is saying is
defamation.
But there are number of FIRs over here, my lord.
That is a non-cognizable offence, definitely, isn't it?
I will try to satisfy.
Just say on the request made on the petitioner. Oh, Mr. So-and-so, just say, appearing for the petitioner, 6 grant of, how many?
2 weeks, Lordship.
2 weeks time.
I have no objection.
6, just say Mr. So-and-so, appearing for the petitioner, makes a prayer for adjourning the matter by 2 weeks. The learned counsel appearing for the respondents have no objection. Prayer allowed, list for 2 weeks.
Obliged.
Some more matter is there.
Obliged.